SJC-12382, Commonwealth v. Raymond M. Concepcion.
Thank you. Attorney Billowitz.
Good morning. May it please the court, Elizabeth Billowitz for the defendant appellant Raymond Concepcion. Raymond was 15 years old with an IQ of 66 when adult gang members drove him to the victim and instructed him to shoot. His youth and intellectual disability were improperly disregarded at every critical juncture of his case: indictment, trial, and sentencing. As a result, he's now serving an above minimum sentence of life with the possibility of parole only after 20 years, while the adults, his adult co-defendants, are serving 12 to 14-year sentences. I'd like to start with the grand jury indictment.
Can I ask you on that score, on the Walls Act? You would ask us to basically change Walls Act because, of course, that was forward-looking, and here your client was indicted 2 weeks before that case came out. So you would have had the district attorney's office basically to go back to the grand jury when there was no requirement to do so under Walls Act, correct?
That's exactly right. It's long been the law, both federally and in the Commonwealth, that where a court announces a new criminal rule that's rooted in a constitutional requirement, it must apply to cases that aren't yet final on appeal. And
that's unless we say otherwise, though, right? Because I thought we said otherwise in Walls Act.
No, that rule of Griffith v. Kentucky and Dagley, that applies even when there is expressly prospective language in the new rule. And
so when we said future cases in Walls Act, we were wrong.
It's not that you were wrong. It's that that did not apply because Walls Act announced a constitutional rule. It did not, that prospective language didn't bar defendants whose cases were still pending on appeal. And
yeah, that was my question. Where you would draw that line?
It's a fairly bright line, and it turns entirely on not on whether there's prospective language in the case, but on whether the new rule that's announced is constitutional in nature. And that this court's most recent retroactivity case law actually makes that very clear. In Commonwealth versus Martin, this court considered whether changes to the felony murder doctrine announced in Brown should apply to a defendant whose case was on appeal at the time, and Brown's new rule was explicitly prospective. However, Martin's analysis didn't turn on that. It only looked at whether Griffith v. Kentucky and Dagley should apply.
Was Grassi also wrong then when we said that Walls Act was prospective?
Grassi was dicta. The main issue in that case was whether the rule of Walls Act should be expanded to pertain to adults as well as juveniles. This court did so and then stated in the alternative, even if the Walls Act case had applied to adults, that case was decided 3 months after, and noted the prospective language. I looked at the briefs in those in Grassi. There was no briefing about the admittedly complex doctrine of retroactivity in that case. It doesn't appear that it was addressed at all in the opinion. That should be treated as dicta.
So every juvenile that was convicted, I mean, I guess it's easier, right? Because after Walls Act came out, there was notice and the like. So your issue would be anybody who was charged or on direct appeal would have the benefit of Walls Act.
That's exactly right. So it's a much narrower group. I mean, this is not a situation where it would be applied to collateral challenges on Rule 30. This would apply to a small group. And I would also,
So if someone were convicted, so they're in that group, you would say the remedy would be to vacate the conviction and have them go back to the grand jury?
That's correct. And that certainly would have been a very easy thing for the judge to have done in this case. Counsel promptly made a motion long before this case was tried. It would have been easy to send down at the time. obviously more complex now, but that absolutely is the remedy, would be dismissal with prejudice and the opportunity for the Commonwealth to go back before the grand jury with the proper instructions that Walzak requires.
And that request was made, was that request actually made at the time?
Yes. Raymond's counsel did file a motion for transcription, and there was an opinion by the trial judge, was also the motion judge, and his reasoning was erroneous. He said that Walzak was not a constitutional rule, and relied on a little bit of a stray comment by the dissent in a discussion of whether the Supreme Court's trilogy of Eighth Amendment cases required the instruction. And Justice Lenk even responded to that in her concurrence and said, I haven't suggested otherwise. It's clear from both concurring opinions that together formed the rule in Walzak that this was a constitutional rule based in due process requirements in Article 12.
Are you familiar with some of, I'm sorry, did you finish answering Chief Justice Budd's question?
Yes.
Are you familiar with at least this federal case law that says that any defects in a grand jury proceeding are cured by what happens at trial? And here, the issues of his mental impairments were litigated at trial, correct?
That's correct.
And rejected by the petite jury.
To some extent, they did reject the premeditation ground, but I am familiar with that line of cases, and that doesn't apply here because the crux of Walzak was that the grand jury is forced into a gatekeeper role between adjudication in the juvenile system versus the adult system. And once they returned that indictment and the case proceeded in Superior Court, then that juvenile adjudication was lost, and nothing the petite jury did could make up for that.
Right, and that recognizes, of course, because as you well know, Walzak is a fragile opinion given the how many different opinions there were in Walzak, correct?
It's true that the rule emerged from two concurrences. I'm not sure I would concede that the rule is fragile as a result. I mean, clearly it's limited to the ground that both of the concurrences share.
Yeah, I don't mean to distract you, but your answer to my prior question was that doesn't, the petite jury saving the grand jury, that doesn't apply when the grand jury has a gatekeeper role.
That's correct.
Yeah. And then let me ask you, while I have your attention, and maybe you can get back on track. If you want us to change the law regarding whether the duress instruction is applicable when it involves death, correct?
That's correct.
Well, and I didn't look at it, and maybe I should have, but is that a majority view, or is that unique, or where other cases, other states come out on that question, if you know?
I'm afraid I don't know off the top of my head. So Vasquez's holding that duress is unavailable as an affirmative defense to murder is the rationale is that people who know that they can claim duress would be more likely to follow a gang order to kill instead of resisting if they know that they have to face the consequences of their act. And this rationale simply doesn't apply to a child with such a limited ability to understand the situation, to resist the pressures imposed, and to understand the consequences of his actions. It's unlikely that this child would even be able to comprehend the legal defense of duress, much less make a reasoned decision whether to yield to adult gang members on this basis.
Do you want us to make a subjective inquiry on that issue as opposed to just having a blanket rule for all juveniles?
That's correct. That's correct. And I also would point out, I would ask this court to change that that rule, or at the very least to give Raymond relief under section 33E. And that is something that Vasquez explicitly holds open, was that this is something that can be addressed in 33E.
I mean, the government, of course, agrees with you with respect to the Miller factors for parole eligibility for 15 years, correct?
Yes, and while acknowledging that that the Commonwealth has done that, we would submit that that does not go far enough. Unless anyone has further questions about the grand jury and Walzak, I'd like to turn to the constitutionality of Chapter 119, Section 74. Raymond, like every other 14 to 18-year-old charged with murder in the Commonwealth, was automatically excluded from the protections of the juvenile court and tried as an adult. Superior court jurisdiction is automatic. There is no longer any transfer hearing. There's no opportunity for remand or any judicial consideration of individual characteristics or the circumstances of the offense. All discretion vests in the prosecutor. Each child charged with murder is tried identically to each adult charged with murder in the Commonwealth. And of course, each child convicted of murder receives a life sentence. Massachusetts is an outlier. There are only 7 other states that have mandatory transfer of children out of the judicial system, coupled with mandatory life sentence. There is a majority of states that have discretionary transfer for children who are charged with murder, and this provides individual consideration of youth on the front end of the judicial process. There's also a majority of states that have discretionary sentencing, providing individualized consideration of youth on the back end of the judicial process. And some states have discretion on both ends. Very few states have neither. That's the category that Massachusetts falls into. We are one of only 8 states with a statutory scheme that's mandatory and automatic, both in adult trial and in life sentence. And this contravenes a general legislative trend away from treating children as adults. And I would certainly recommend to the court the amicus briefs that were submitted that provide detail as to that trend. Walzak explained that the differences between how a juvenile is treated in juvenile court versus superior court are considerable. There is an underlying policy mandate. The juvenile justice system is primarily rehabilitative, cognizant of the inherent differences between juvenile and adult offenders, and geared toward the correction and redemption to society of delinquent children. Juvenile court judges and probation officers receive training suited to their protective role. They're knowledgeable about juvenile development. They have experience dealing with children. And children adjudicated in juvenile court, they receive the benefit of statutory interpretation that favors these policies.
What would meet, in your view, constitutional criteria under 8th Amendment, Article 26? Would it be the old transfer hearing, or would it be something less than that?
Yes, the transfer hearing system that was in place from 1975 to 1996 contained enough consideration, individualized consideration of youth, that it would satisfy Miller. Obviously, it would take the legislature to revive that. Right now, we only have transfer hearings in the very limited circumstances where a juvenile is only apprehended after age 19. But the system that was then in place was somewhat prescient in satisfying Miller's concerns. Fully discretionary sentencing, which obviously is a question that this court has reserved several times, Brown, Okoro, Lugo, Watt. I know this court has been reserving that without conceding that that would make trying a juvenile as an adult constitutional, I would say that that would remove the major problem with our current scheme.
In the discretion to impose different lengths of parole eligibility is not far enough in your view?
It's not. And to further, before addressing parole further, I also just want to complete my answer what would happen if we were to get rid of Section 74 right now, which the mandatory exclusion from juvenile court, is that children accused of murder would be treated like other youthful offenders, and that the youthful offender scheme, other than its exclusion of children charged with murder, also would satisfy Miller. That there is sufficient discretion and consideration of youthful characteristics in the disposition of those cases. Juvenile judges in youthful offender cases can provide a range of dispositions ranging from DYS custody until age 21 to a complete a full adult sentence, or a combination of DYS custody to age 21 and then a suspended adult sentence, which I would submit would likely be an attractive option in a case of a juvenile charged with murder. And I also want to point out that option of providing DYS custody to age 21 would have made a tremendous difference to this particular client. He was in DYS detention for the years between his arrest and his trial. And this was the environment where he made remarkable progress, developmentally, academically. He had counselors, he had one-on-one tutoring. His capacity for rehabilitation and growth were being met in that environment. That is not available to juveniles who are charged with murder and are removed from the juvenile system. To say a little bit more about remedy, if we strike down, if this court strikes down Section 74, some of the other statutes that prescribe sentences for juvenile, for those convicted of juvenile murder would not be applicable. And I would want to point the court to Chapter 11972B and 265, Section 2B. Both of those statutes use the language, if a person is found guilty of murder in the first degree, or any person who is found guilty of murder. Those statutes could stay in place because if a child is adjudicated as a youthful offender, they're not found guilty. They're not convicted, rather they are adjudicated a youthful offender. So this court would not need to entirely lay waste to the existing statutory structure. All it would need to do would be to strike down Section 74. The legislature could act to reinstate the transfer hearings, or cases could simply proceed like other children charged with felonies under the youthful offender scheme. I see that I don't have much more time. I would like to address another important issue here, which is the constitutionality of a life sentence in light of intellectual disability. Raymond's automatic sentence of life was unconstitutionally disproportionate because he was both a child and intellectually disabled. And these two groups each have diminished culpability based on their impulsivity, their poor self-control, and illogical reasoning. And they also share vulnerability to outside pressures in criminal environments. And this makes the most severe punishments excessive. His intellectual disability and his youth provided distinct and cumulative basis for an individualized sentence. And this double burden wasn't just theoretical. There was evidence at the trial. Dr. Ayub testified that he had much less capacity to understand the consequences of his actions than the average 15-year-old, both due to his intellectual disability and to his trauma history. The Commonwealth concedes that this sentence was indeed disproportionate in light of his disability. And while this concession is welcome, 15 years is still disproportionately long, and the availability of parole doesn't render this life sentence constitutional, because children are entitled to a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. And the qualities that entitle Raymond to judicial consideration of his specific traits also constrain his chances of release on parole. The Supreme Court in Atkins noted that the intellectually disabled are typically poor witnesses. They have difficulty assisting their counsel. Their demeanor can create an unwarranted impression of lack of remorse. And even the Commonwealth here has acknowledged that parole for this particular individual might be a very, very difficult challenge. And the Commonwealth expressed hope that opportunity will be available to him. The hope is appreciated, but of course it does not bind the Department of Correction or the parole board. So Raymond here is seeking individualized discretionary sentencing. A child with the cognitive function of a 10-year-old was sentenced to the most severe punishment any juvenile in Massachusetts can receive. And his disability didn't shorten his sentence, and it wasn't even considered. And this violates the principle of proportionality. In addition,
Oh, wait, we're past time, so.
oh, good. Yes, we are.
If it's in your briefs, we've got it, and I thank you.
Thank you very much.
Attorney Campbell?
Thank you. Good morning, and may it please the court, Cailin Campbell on behalf of the Commonwealth. I'd like to acknowledge Jennifer Hickman, who is the trial prosecutor in this case, as well as the victim's family, who are all watching via the live stream. We ask you today to affirm the defendant's first-degree murder conviction for the execution of Nicholas Martinez. This is a case in which the defendant has never contested his role in the crime. He was part of a group who tracked and hunted the victim, and the defendant was the person who admittedly shot the victim. At trial and here on appeal, he solely contests his culpability in a variety of ways. But based on the evidence that was presented at trial, there is no basis to reduce the verdict in this case. I'd like to start with a question that Justice Gaziano asked as to duress. Specifically, the question was, how do other states fall with duress as a defense to murder? If you look at the Vasquez case, it has a long history and explains sort of jurisdictionally where states fall on this, but specifically it says it's not a defense at common law in any state, and every state but one has held that duress is not a defense to murder. The Commonwealth suggests that that this court should uphold Vasquez and not revisit it. I also would point the court, though, to reasons in the evidence why a duress defense was not appropriate in this instance. It's really not supported by the defendant's actions. While true that in an interview he told the police that he shot the victim because of influence from two older gang members and to get out of the gang, once he did complete the shooting, he did not take any actions that would suggest that he was trying to distance himself from the Mission Hill gang. Quite to the contrary, evidence was presented at trial, specifically from Norma Hollenbach, who was a DYS caseworker that worked with him, as well as Dr. Ayub, who was the defense expert in this case, that the defendant, even while in DYS custody, removed from these gang influences, continued to show allegiance to the Mission Hill gang. That continued through the pendency of his both DYS custody and custody in adult prison awaiting his trial, and statements that he also made to the Commonwealth's expert, Dr. Martin Kelly. So ignoring that this is not a recognized defense either in the Commonwealth or 49 of the 50 states, the evidence itself doesn't support that this defense be given as a jury instruction. Turning to the first claim my sister spoke about, the Walzak claim, I disagree with her recitation as to retroactivity and what the Brown case holds. And I would tell the court that the best description and analysis of this is at 645. I'm sorry, I said Brown, but I meant the Martin case. It's at page 645 specifically. And at page 645, this court held that because Brown didn't establish a new federal constitutional right, nor a new rule of criminal procedure, Griffith and other federal retroactivity cases were inapplicable to the analysis of the court. I would say that the same rationale and reasoning applies here, that Walzak was explicitly prospective only, and that the analysis that my sister says Martin supports simply isn't borne out by reading the analysis of it.
Was Walzak constitutionally based? Was it a due process right, or what was the base? I know that's a difficult question because there's so many Walzaks, but.
Yeah, and listening to my sister's argument, I did pull up Walzak and I was reading through it trying to figure out the answer to that question. And I guess I would go back to the Martin case. So Martin talks about Brown, which changed the liability under felony murder, which is common.
Yeah, I'm aware of that.
Yeah, no, I know. I would say that where this is talking about presentation and the culpability and degree of murder to a grand jury, that it would fall into the same category of cases. That's as best as I can. That's the best answer I can give you, because in reading it, I can't. It was hard for me to figure out the answer to that question, but I think Martin supports that it isn't necessarily a new constitutional law. It just has to do with sort of culpability of murder, and in this case, the indictment that is returned. Moving to the statutory argument raised by my sister, it is our contention that this court not strike down General Law Chapter 119, Section 74. The statute simply confers jurisdiction over a certain class of defendants. The Eighth Amendment and Article 26 specifically speak to the punishment that's imposed and not statutory jurisdiction. So I'd say that this case law cited by my sister is simply inapplicable to the question that needs to be asked by this court. As recognized by this court, where age is the classification that is really at issue here, all that needs to be upheld for the statute to be constitutional is a rational basis for the jurisdiction in this case. And I'd suggest that the rational basis here is that murder is the most serious offense that can be committed in the Commonwealth, and conferring jurisdiction upon the Superior Court, who routinely hears such cases, is certainly rational given that. Also, where murder is the most culpable and serious offense, conferring, again, adult jurisdiction to deal with this type of serious offense is rational under any sort of constitution.
But it also greatly influences or correlates to punishment, though, right? Because once they come under the statute and they're convicted of first degree, as you know, in what your office has done as far as parole, it cabins punishment. So it's not just jurisdictional; it's also punishment.
It's not jurisdictional, but I think that there is where it's important to see what the case law holds in regards to the Eighth Amendment and Article 26, and as it relates in cases like Miller and Diachenko, which is that in crafting an appropriate sentence, the individual characteristics of the defendant's age there has to be an opportunity, and they need to be considered. Here, based on the statutory scheme, that is based on the parole eligibility date, and I'd say that based on the laws that currently exist, that satisfies.
But I guess that is the issue, though, right? Is whether or not that statutory scheme that allows for a judge to set parole eligibility between 15 and 20 years is sufficient to fully vest the defendant with their Eighth Amendment, Article 26 rights under Diachenko and Miller, correct?
Yes, and I believe if you read the specific language of both Miller and Diachenko, it's just the meaningful opportunity of parole that needs to be considered, and certainly that is considered under the statutory scheme. So really what violates the Eighth Amendment in Article 26 when you read those cases is the lack of any sort of parole eligibility date, right? And so it is when you read what those cases stand for, certainly I don't think that it suggests that the statutory scheme as it exists violates either the Eighth Amendment or Article 26.
Can I ask, this might not be particularly raised in this case or relevant, but as I'm thinking about some arguments that Attorney Billowitz made, she points out that the the defendant was, when he was in DYS custody, was doing very well in terms of services that he was receiving. What kind of services are available, if you know, in the Department of Correction for younger defendants so that they can build toward the chance of getting out in 15 years?
I don't want to speak without fully knowing every single service that is provided to younger defendants. I don't have the answer to that question.
That's okay. That's fine.
But certainly, when looking at, again, I would point the court towards Miller and Diachenko, and looking at what they specifically hold in with particularity to the Eighth Amendment in Article 26, and say that this statute does not offend that. And it's really a statutory question. What this is an attack, again, on the constitutionality of a sentence with life with the possibility of parole. And this court, as recently as June of this year in Watt, upheld that that was a constitutional sentence. You know, it is true that the question is left open. I don't think that this is the case to answer that question. And the reason why I don't think that this is a case to answer that question is because if you look at the record in this case, the defendant's own expert testified that she didn't base her opinion on the characteristics of an adolescent brain. She really based her opinion on this specific defendant, his individual characteristics, and his history of what he had went through.
Can I ask you about 33E review in your office's concession that it should be a 15-year parole eligibility? Why wouldn't those same considerations that your office has gone through compel us to exercise our 33E authority and reduce the sentence, the conviction to a second degree?
Sure.
Aren't they the same considerations?
I don't believe they're the same considerations, because in 33E, one of the tasks that the court is asked to do is to look at this defendant and the crime that he engaged in and compare it to similar defendants who committed similar crimes and ask whether that falls within the range of sort of what is acceptable.
Well, we've also looked at individual characteristics of defendants.
Absolutely.
As well. A case out of the North Shore comes to mind. I forget the name of the case that I wrote, but we did that when reducing a sentence. So I guess if your office can do it, why can't this court do it is the question. Yeah,
and it's a good question. It's a really good question, because the Commonwealth recognizes that the position that it took is not typically what the Commonwealth advocates in a first-degree murder case. We fully recognize that. But I think that if you look at the evidence in this case, why we didn't suggest that to the court, I guess, is the way that I'll frame this, is that it fully supports a verdict of first-degree murder with extreme atrocity and cruelty. I disagree with my sister that the only factor that we could point to was the degree of the victim's suffering, which certainly existed in this case based on the evidence that he was gurgling, that he was awake for a period of time, that his girlfriend yelled at him to go, and he was able to actually step on the gas pedal and his car crashed into a car near him before coming to rest on a median. But there are other factors at play here too, which I think are important, specifically the manner, degree, and severity of force used, the nature of the weapon and the method used, and the disproportion between the means used to cause death and those employed. And that's
Campbell, can I ask you, I understand how you get, we reduced the verdict under Justice Gaziano's approach, but when I read yours, it was very interesting, because you're basically saying they got no basis, they got no basis, they got no basis, but guess what, we're going to lower it based on proportionality. But you didn't find a cruel or unusual punishment proportionality. What do we cite if we lower this? What is the legal basis for us reducing this besides prosecutorial compassion?
Because we'd have to say that the sentencing judge who heard all the evidence got it wrong.
Yes, you would.
And on what basis? I'm just trying to understand the legal basis he was wrong.
Absolutely. So in this instance, anytime you're looking at a sentence under the Eighth Amendment or Article 26, what you're tasked with asking is whether it's proportional. And not only is it proportional, but you have to look at the specific offender and the specific offense. And it is District Attorney Rollins' contention that based on this specific offender and the facts of this specific offense, the sentence that was imposed is disproportionate under the law.
Are you saying that it's a cruel or unusual punishment under the law, or cruel and unusual? I'm reading along and I thought you didn't find it cruel or unusual. It wasn't, but then we get to your compassionate solution, which I understand and I'm not disagreeing with. I'm just trying to understand, are you saying that the judge violated, that's a cruel or unusual punishment, or just that you'd like him to redo it?
In this particular instance, yes. The Commonwealth recognizes that in its brief, it does. I guess I want to be clear that the position that the Commonwealth is taking is that it is not that a sentence of life with the possibility of parole upwards to 25 years for juveniles per se is unconstitutional. We believe that under the current law, that is a legal sentence in which a judge could impose. The Commonwealth's contention is that in this specific case with this specific offender based on this specific offense, that it is a disproportionate sentence.
But it has to be based upon his personal characteristics, correct? Because we have a juvenile, we have an execution. So those are, those are a 25-year, 20-year. In that case, the judge got it right. But is it because of his mental deficiencies or that have been pointed out?
Sure. I think the answer. Oh, sorry. I'm sorry.
No, I'm just thinking out loud. I'm just trying to, because I think what Justice Kafker's getting at is we're tasked with writing this and having a rule that applies not just to this defendant, but to all, the next case and the next case after that. And we can't just, we need some basis to do that is repeatable. So
yes.
How would you write that rule?
How I would write the rule is I would cite to the 8th Amendment and Article 26 standard. I would say that any proportional sentence has to look at the specific characteristics of the defendant and the offense. And then I would say, looking at this specific defendant and his characteristics, which while they do include the factors that Your Honor just mentioned, they also involve other factors. The first primarily is that he was 15 years old. And while that doesn't negate the ability of an individual to have the intent, the specific intent to commit murder, it definitely is a factor that should play into a consideration of a proportional sentence. The second is this defendant's particular history. Now with the IQ, I want to be careful as to what the Commonwealth, it was thrown around that we conceded a lot about the IQ, but it's that we recognize that he presented evidence that his IQ was in his expert testified in the 66 to 71 range. That didn't preclude him from having the specific intent to commit this murder, but it does play into his individual characteristics that should be.
But you argued otherwise at trial and had an expert that said otherwise.
We had an expert that said he called into question his the IQ numbers. He didn't offer contrary IQ numbers. He called into question. I don't think it's a contrary position, because I think the Commonwealth is still saying here and did at trial that the level of disability that this defense expert testified to, we contested that level of disability. And it certainly was for the jury to draw a conclusion as to that level of disability.
Right, which leads me to my initial premise when you write this and we say, because you're basically, we're not going to look at it in a light most favorable to the defendant when you argued otherwise at trial. But the age is undisputable. He was 15.
Correct.
And I think, is it also not in dispute that he had intellectual disabilities?
It is not in dispute. It's also not in dispute that he had past trauma, which could come into play as to sort of the actions that he undertook. But I also think another factor that the sentencing judge could consider, and certainly this court can consider, is the sentences of his co-defendants. And I would point to the Tejada case, which is 481 Mass 794. Although that's in a different context, I'm using it by analogy. It's in a Rule 29 context, but it explains in a joint venture context, a sentencing judge can consider the sentences received by other coventurers who may have had more culpability but received a lesser sentence. And I'd say here, where the older members of the gang, who are the driver and the front seat passenger, who there's evidence to suggest did assert some sort of pressure on this defendant, that the fact that although they did plead guilty and in pleading guilty avoided trial, that they received a 12 to 14 year sentence is a factor too that can be considered.
Because you recognize that if we do this, and I'm not saying we won't, but if we do this, this is going to set the standard for judges to look at going forward when they're trying to assess parole eligibility in these cases.
Absolutely. And, you know, I think that all of these factors are things that should be considered by judges, you know, due to the way that the statutes have been amended and changed. I don't think there is much guidance as to specifically how a judge is supposed to consider in this specific context with juveniles a parole eligibility range. So yes, I would welcome sort of discussing these factors and how they should be addressed by a judge in crafting an appropriate proportional sentence.
Justice Gaziano, are you?
Yep.
My question then is, how would this proposed language, which we've made you say, how would that apply to other cases that are in the same position as this defendant, or were at the time, maybe going back many, 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 many years? Wouldn't they apply also?
As to a retroactivity analysis,
Yeah.
it's individual, you know, that is a good question. I think it wouldn't be creating, you know, it certainly would be something that a defendant could raise always, and has always been able to raise under a Rule 30A motion to say my sentence is unconstitutional. And I think a juvenile defendant could raise that even now based on the development of both law and science as to the adolescent brain. So I don't think it's sort of creating or opening the floodgates in a way that isn't already sort of available to any juvenile defendant who's in custody.
Okay.
Seeing that I have 0 time left, the Commonwealth asks that you do affirm the degree of murder of this brief for the execution of Nicholas Martinez, and we will rest on our brief for the remainder of the arguments.
Thank you so much. We'll take a 5-minute break and then go back to the Cailin case.